Yes, Miss Weston.
Good morning, my lords, my lady. Initially, I should first of all apologise because I'm a little bit post-viral. Although I'm not contagious, I am struggling a little bit today, and so I brought equipment with me to assist that process, and I hope that it won't hold anyone up.
I can certainly hear you so far.
I'm grateful. Could I first then make sure I understand we've already been informed by the clerks that all the bundles have been received, so the court should have 3 bundles. I'm grateful. There are 2 further documents that I'd like to hand up today, which may be of assistance to the court. The first is, I've agreed them with my learned friend. The first is a document relating to the underlying judicial review, which is the consent order of the disposal of the original JR,
Yes.
which is signed but not sealed. And the other is a chronology which has been prepared by those sitting behind me of the legal aid decision making, so the courts can see the dates at which all the legal aid decisions were made. It's not disputed. I'd like to hand those up if I may.
Yes.
While that's happening, I'm being assisted today by Mr Percy and Mr Isaac Ricker Richardson, who are sitting behind me, and we have from the Public Law Project Miss Moxham and Miss Vincent Miller also here, and I'm being opposed, as the court knows, by Mr Birdling and Ms Bird, who I don't understand them to have anyone sitting behind them.
I think I've been given 3 copies of the same thing.
I have 2.
Draft consent order.
I've got the chronology.
I've got the chronology.
Do you want my chronology?
Let's see, I've got one chronology, that's great, and 3 consent orders. Anybody else like a consent order?
I'll take one of those.
Right.
And I've got no chronology. Does anyone want one? No? Are we okay?
Nope.
Right.
The spare chronology, I'll take those, thank you very much. So, in order to speed my submissions, I intend to make some reference to the chronology as it may assist the court. So, the court will be aware that we have a rather narrow issue troubling us today.
Yes.
And the order which is being appealed, the court will find at Core Bundle 52. That is an order by Mr Justice Ockleton, Deputy High Court Judge Ockleton. And we can see there that the reasons of the learned Deputy Judge are quite short. Effectively, he says he agrees with the defendant's detailed reasons for the making of the order in the prospective form.
And
the narrow
the reasons that are set out at pages 72, 73 and 74.
That's right. And indeed, actually, if I can turn the court to 53 and 54 of the supplementary bundle. Sorry. Oh, it's the same. Yes. That's the document is also there, but it's the same reason. So that's effectively what the judge agreed with, and I'll come back to those if I may. The issue, we say, is well set out, as one would expect, by Lady Justice Lang, granting permission at CB 54, tab 7. What should happen when the administrative court makes a cost capping order, a CCO, in an application for judicial review on the basis that a claimant does not have legal aid to pursue that application, and the legal aid agency later gives C legal aid for that purpose, which is backdated, and therefore covers all the claimant's costs, including those incurred before the date when the legal aid certificate is issued. And I would simply add there, although the judge does go into it in a bit more detail further down the page, that would also include the backdating of cost protection.
And we're agreed, aren't we, that the appeal against Mrs Justice Collins Rice's decision is really neither here nor there.
Yes.
If you succeed in overturning Mr Ockleton, then Mrs Justice Collins Rice doesn't matter. But if you fail in overturning Mr Ockleton, then it must follow that Mrs Justice Collins Rice was right. So we're just looking at the one appeal.
Absolutely, that's right.
Good.
And I think that the thinking behind pursuing that appeal was really, as an advocate and as a legal representative, mindful of the pressure on the Court of Appeal's time, one would always normally seek to renew orally an application which had failed on paper, and to that extent there is some guidance saying that's the right thing to do. But here, obviously, a different approach was taken, and it was thought that it may be useful to have guidance on that. But as the court could see, that point is no longer being pursued.
Yeah, right.
And in respect just of something you said, your original application was for a no oral hearing. You wanted it dealt with on the papers.
That's right. Yes,
and that's what led to the making.
It was ticking the box, which had, on one analysis, jurisdictionally deprived Mrs Justice Collins Rice of the ability to review it on an oral hearing. So at this point, there's just one more sort of overarching point I wanted to make about the nature of the point before us. Nobody here is saying that the court can't make an order of retrospective effect. Nobody is saying that there is any jurisdictional bar to varying the order with retrospective effect. And I'll be taking the court to some case law where indeed it was the Defendant Government Department that was seeking retrospective amendment. That's the Appellant case, which I'll come to in due time.
And can we just clarify this, please, Miss Weston? The focus of your argument is on the retrospective effect, because, as I understand the letter, it was agreed by the respondents that prospectively they would accept cost cap, and I can see you nodding.
Correct. Yes. That's quite correct, my lady. So, in essence, then, the issue before the court is not whether the court has a power or had a power to make an order of retrospective effect, but whether it should have done so. Not whether it could, but whether it should. I also mentioned at this stage that the grant of permission identifies an important point of principle arising in this case relating to the retrospective aspects of the application made. And we would say necessarily that point of principle also arose for determination by Deputy High Court Judge Ockleton. So my submissions, I propose to take the following course. Firstly, to make some short submissions on the facts. Of course, the court will be assisted when determining the issue of the factual context in which it arises. Secondly, to make submissions on what assistance can be drawn from the statutory framework and the case law. And lastly, to make some short submissions on the appellant's grounds. So, taking the first of those items, the facts, this appeal arises because T.I. and her husband are the foster parents of C.R., a delightful young person, now aged 6, who, like many young people who have struggled with a challenging start in life, is very bright but has some complex special educational needs. T.I. and her husband agreed to foster C.R., but they are of modest means, relatively, and when they needed to pursue an appeal in the Special Educational Needs and Disability Tribunal, in order to secure CR's access to the curriculum, that's to say the help she needed in order to pursue her education, in light of her disabilities and difficulties, the solicitors acting on their behalf, Simpson Miller, made an application for exceptional case funding for that purpose. That original application was made on the 5th of July 2021, as one will see from the chronology. That was finally refused. The court will see that there was some interim correspondence, but that was finally refused on the 9th of September 2021. And we find that decision at Core Bundle 165 to 166.
Yes.
That was then the subject of a review application, which was refused. And the application the application for the review was refused on the 3rd of November 2021, and we find that decision at supplementary bundle pages 4 to 8.
Yes.
So that decision was then subject to a request for a review on the 8th of November 2021, and then finally refused we see that decision at supplementary bundle pages 9 to 10. And we can see that the reasoning of the court there, I shan't read it out, but effectively the decision of the legal aid agency was that the TI and her partner, as prospective adoptive parents, should not be treated as acting in a representative capacity, but as effectively as parents, as normal parents. Now, that was the case, notwithstanding that at the time the local authority maintained parental responsibility for the CR. Now, importantly, there's just one matter I wanted to turn up. At the bottom of the page, it says here that under Regulation 53 of the Civil Legal Aid Procedure Regulations 2012, there is no further right of appeal to an independent adjudicator against this decision. Now, I understand that although Mr Birdling and Ms Bird, in their skeleton argument at paragraph 8, assert that there was a right of appeal that could have been pursued, it is now the position that Mr Birdling is nodding agrees with me that in fact there was no right of appeal, and that was because this was an application for emergency legal aid and not an application for full legal aid.
So that explains the next sentence. It's open to you to submit a substantive application. That means non-emergency.
Exactly, and quite so. And that is a further application which would have taken more time.
Yes.
And I think it's fair to say that it involves the gathering of somewhat more information.
Yes.
And it's right to say that it would be a reasonable position taken by a person, particularly dealing with a matter concerning the best interest of a child, to take the view that that would be quite potentially a lengthy process with, if the reasoning was maintained, the same outcome, subject to an appeal, which of course would take more time. So it was against that background that the CCO was applied for. The application for the CCO itself can be found at tab 4 of the supplementary bundle. Page 14, and we can say that the reasoning behind the application for the cost capping order is set out at page 18 onwards. And the witness evidence as required by the process under the CPRs and under the statutory process of Mr. Daniel Rourke is contained at page 24.
Well, it was a proper claim which Mr. Smith allowed.
Indeed, quite.
Yes.
I'm grateful. So that order then was granted as the courts identified by Mr. Smith, sitting as a Deputy High Court Judge. We see that decision in Core Bundle Tab 12, page 95.
So Mr. Smith had before him both application for permission and application for
That's right.
cost cap.
That's right, because of course, as the court will be aware, the CCO can only be granted in the event that permission is granted to apply for judicial review.
Yes.
Mr. Smith also had the defendant's response to the application for the CCO. I've temporarily mislaid the page reference for that. I'll just go back. But in any event, the order was made. We see that at
85?
yes, 85 and sorry, 95. Tab 12, page 95 in the core bundle. Now, at this point, I should point out that the nature of the CCO granted by Mr. Smith wasn't precisely in the terms of the order sought, and the best way to see what impact that order had on the recovery of costs for the claimant in the event of a successful judicial review is at the back of the supplementary bundle, where there is a schedule dated the 10th of February 2023. We see it at tab 24.
You keep referring to numbered tabs, but speaking for myself, I don't have.
It's
Doesn't
supplementary
matter,
bundle,
but
page 86.
yes, stick to page numbers.
Will do.
Yes.
So that is a schedule which was submitted with the consent of the defendant and interested party and pursuant to the order of Lord Justice Dingemans at page 90. But in any event, what that schedule does, from paragraph 8 onwards, page 88 to 89, is set out clearly what the difference would be between what the appellant is currently able to recover in light of her success under the underlying judicial review, as compared with what would be recoverable on privately paying inter partes rates. So it's a significant difference between £36,000 inclusive of VAT and disbursements as opposed to potentially £84,444.74. At this point, I remind the Court the observations of the Supreme Court in the JFS case, which I'll come to shortly, about the importance of ensuring that legal representatives whose work involves was primarily aimed at assisted publicly funded parties need to be able to recover their costs from an appropriate case at inter partes rates in order to make the continued availability of such representation viable.
Wasn't that directed to the very typical case where an application for judicial review is launched with backing from a public interest body such as PLP? The respondent, very often the Home Office, but not necessarily, capitulates at some point, but then argues that there should be no order as to costs. And Lord Hope said in the JFS case, you mustn't give in to that too readily, because if that's done all the time, then the public interest litigation supporters such as PLP can't carry on.
That's right. My lord is correct. The context was different. We would say, however, that the general principle applies, which is that, particularly in a context where Parliament has provided that CCOs are made available in an appropriate case in order to ensure that appropriate public interest points get litigated and ventilated, in the same way, this court shouldn't place roadblocks in the way of individuals recovering at inter partes rates in an appropriate case where there has been a success.
Well, is there anything in the JFS case, or indeed any other reported appellate case, where the point you've made is directed specifically at the rate at which costs can be recovered, i.e. Commercial as against GLD or legal aid rates, rather than the difference between making an order for costs and making no order for costs?
Not specifically, and I think we all agree that we're in slightly novel territory in this context. But I would observe that even in the JFS case, for a party with public funding, their costs would be recoverable, but at legal aid rates. It's in JFS, it was the difference between recovering your costs in terms of a no costs order from the legal aid agency, or recovering them from at inter partes rates. So that difference was still in play. I ought to also observe that maximum of 84,000 obviously would be subject to detailed assessment and likely would be reduced. I have to accept that. But we are still looking at a significant, I think, sorry, there's whispering behind me. May I just turn my back for a moment?
Yes.
Yes, what's being pointed out to me is that the cap being applied here is actually lower than the legal aid rates that would be recoverable. But yes, I have to accept that on a detailed assessment, it's likely that those costs would be reduced. It varies, but it's usually around the order of 20 to 30%. I have to accept that that's a possibility in this case. So then, in light of the grant of permission, by Mr Smith, a further application was made, we can see from the chronology, for legal aid in light of the grant of permission, and it was granted on the 1st of March 2022 and backdated to the 10th of December 2021. In other words, covered the whole of the period of the costs incurred by the claimant's representatives and the claimant.
And that's standard in a case where legal aid is granted after issue.
After permission.
After.
My understanding is that if an application is made post-permission, and the court has deemed the case arguable, it's the practice of the legal aid agency, I'm sure Mr Berger may be able to assist further, but is to backdate to the beginning of the work on the case such as it would have been covered by a certificate. Then there was the application to set aside the CCO, and we can see that at Core Bundle tab 11. Sorry, it's 77 to 94 of the Core Bundle.
Yes.
So that application set out in some detail the position of the claimants. In essence, what was applied for was the setting aside of the cost capping order in its entirety. So that would mean that in respect of both parties to the litigation, and it was an essential part of those submissions that it necessarily followed that if legal aid was backdated to before the making of the order and covered the legal costs, it must mean that there was no need for a reciprocal cap during the period in which, albeit retrospectively, legal aid had been granted. That is to say, if the claimant's cap had gone, there was if the claimant's cap was no longer required, there was also no need for a reciprocal cap. I'll come back to the statutory framework, but it's the essential reciprocal nature of that cap on the defendant's liability, which is key to understanding the claimant's application.
Can I just ask about the original application for CCO?
Yes.
It may be me, but I haven't managed to track down the draft order, the terms of the order that you were originally applying for. The application is at page 14 onwards of the supplemental bundle. Have I missed something?
Page 18.
Sorry, my lord.
It may be, I mean, because the application notice says that a draft order is attached, that's what I was looking for, but
Yes.
I haven't found one.
I'm sorry.
Yes.
Yeah.
Yes, the
that's all
actual
we have.
draft order is not there. It was submitted, my lord is quite right, with the application, but it's not in the bundle.
But was it in the terms of submissions, page 18, supplementary bundle, paragraph 2?
That's right.
So the only the difference that emerged from the deputy judge's decision was a variation in the amounts, but not in the rates.
That's right. So then, if we could turn up the defendant's response at pages 72 and 73 of the supplementary bundle. Sorry, the core bundle. So this is a letter dated the 5th of April 2022. The analysis of the defendant here is that, firstly, there's no authority or that rather the authority in which they rely, it seems to indicate that only where there has been a misleading or material non-disclosure at the point of application, should a retrospective order be made. Certainly, although that is a case which does identify circumstances in which the court considered it appropriate to make such an order, certainly there's nothing in that case which limits the jurisdiction to do so in that way. And secondly, summarised the defendant's position in the second paragraph down on page 73. What the claimant is seeking is an order which would deprive the defendant of the protection which Parliament has required as part of the quid pro quo for obtaining a CCO. Again, we would say that that is a fallacious argument, because the consequence of setting aside the CCO in its entirety is that no reciprocal order would be required. There is no necessity for a reciprocal order once the CCO in respect of the claimant's protection had been set aside. What such an order does do is effectively deprive the claimant of her opportunity to recover at inter partes rates following a successful claim for judicial review, which this was. The court has a copy of the order which was made in the underlying judicial review. I'm not going to go to it, the court has it. It's clear there that the normal process in respect to recovery of costs would apply up to the CCO. So at this point I'd like to turn up, if I may, going on to the submissions about the assistance that can be derived from the statutory scheme and from the case law. I'd like to turn up, if I may, the authorities bundle, where the governing statutory provisions are set out at tab 1, page 4.
Yes.
Now, the court will be aware that in legislating for this statutory regime, Parliament was putting on a statutory footing the approach which had been taken by courts previously in respect of protective cost orders, but making some specific requirements for the making of such orders. So, if I can put it this way, Section 88 sets out some mandatory requirements in order for an order to be made. Section 89 sets out what the court must have regard to, so sort of a due regard type duty in respect of particular factors. which militate for and against whether such an order should be made in judicial review proceedings. On the mandatory criteria, we can see that at subparagraph 1, a cost capping order may not be made by the High Court or the Court of Appeal in connection with judicial review proceeding, except in accordance with this section and sections 89 and 90. The definition of cost capping order at 2, but at 3, again, mandatory requirement. The court may make a cost capping order only if leave to apply for judicial review has been granted. The procedural requirement at subparagraph 4. 5, in respect of rules of court. Then if we go down to subparagraph 6, the court may make a cost capping order only if it is satisfied that A, the proceedings are public interest proceedings, B, in the absence of the order, the applicant for judicial review would withdraw the application for judicial review or cease to participate in the proceedings, and C, it would be reasonable for the applicant for judicial review to do so. Now these are, in my respectful submission, mandatory requirements inform, in my submission, the approach that the court should take to circumstances where, owing to a backdated grant of legal aid, the requirements, the mandatory requirements at 6, A, B and C are not satisfied during the currency of that grant. That is to say, once a backdated grant of legal aid has been made, it cannot be said that the applicant for judicial review would withdraw the application for judicial review or cease to participate in the proceedings, or C, it would be reasonable for the applicant for judicial review to do so. In my respectful submission, it's plainly the intention of Parliament that where there has been a material change of circumstances such that at the point at which the application was made, it transpires that costs, protection and a grant of funding was available, the court must, in my respectful submission, I stop short from saying that the court's compelled to. I say that the court must, in my respectful submission, consider whether failing to make an order of retrospective effect would run counter to that clear legislative purpose. That, in effect, was the legal question that Deputy High Court Judge Ockleton should have considered when looking at the application.
There's no issue, but when the original order was made, it was wholly compliant with Section 88.
Agreed. Indeed, this is a situation where a change of circumstances after the grant of the CCO means that applying the backdated nature of the funding, nevertheless, cost recovery stretches back to the point at which the CCO application was made and granted.
Can I get this clear, and the fault is mine? Are you saying that the approach of the Deputy Judge, when he came to make his order, he was bound, because of the material change of circumstances, to apply these provisions, or are you allowing for an element of discretion?
I'm allowing for an element of discretion. I haven't managed... Sorry, my lady.
No, my apologies. I didn't mean to interrupt. So allowing for an element of discretion, is your case this, that he takes account of what is said in section 88 and your reliance on subsection 6 and factors it in, if you like, to the discretion which he is exercising. Is that it?
Yes, the court must consider the effect of these mandatory statutory requirements and whether making an order of the kind sought by the appellant correctly reflects the legislative intention and purpose.
Would it follow that if, let's say, some wealthy benefactor stepped in after leave for the judicial review was granted and said, it's a great cause, here's a large sum of money, would it then follow that the respondent could apply to have the cost capping order revoked, thinking, well, I think I'm going to win and I'd like to get all my costs back? Would that also be a material change of circumstances that might work in the other direction? I think it would follow from your reasoning.
Well, we have an additional factor here, looking at the discretion, looking at the exercise of discretion. We have an additional factor here which isn't present in the example that my lord gave, which is that here it is the government department, the Ministry of Justice, the Lord Chancellor, who have responsibility for the administration of legal aid, who initially refused legal aid and are now saying that costs should be recovered, notwithstanding their costs recovered against them should be limited, notwithstanding that the underlying judicial review in respect to the CCO was successful and was meritorious. So in my respectful submission, there is an additional factor. If Parliament's intention was that CCOs should be available in circumstances where there's no other means of bringing the JR, and it is the defendant's decision-making which has rendered that circumstance, then that is also a matter that the decision-maker, that the court, or whether it's the Deputy High Court Judge or this court, should take into account when considering whether or not making the order with retrospective effect properly reflects the intention of Parliament. Otherwise, it could serve as a disincentive to the defendant for proper decision-making.
Well, I understand that. That's a slightly narrower version of the issue that is identified in paragraph 1.
Well, it's an additional factor to be taken into account on the exercise of discretion.
But it narrows the issue rather, doesn't it? Because the broad issue identified in paragraph 1 of the grant of permission to appeal wasn't tied to the fact that the defendant in the case is the legal aid agency. It had a much broader potential impact.
I agree that the statutory mandatory requirements and the way Parliament has framed them are a very weighty consideration in considering whether discretion should be exercised retrospectively. But it is also, the particular circumstances of this case are a further factor to be taken into account when exercising that discretion.
But it's when exercising a discretion as to whether to revoke the CCO retrospective.
Yes.
As I see it, you accept that when Mr Smith made the CCO, it was entirely proper.
That's right.
One would hope so, as your clients applied for it. And then an application is made that it should be revoked. Consent of the other side that it should be revoked for the future. The only issue is whether it should be revoked retrospectively. There's some debate in the skeleton argument about what are the circumstances in which a cost capping order can or should be revoked. Speaking for myself, I would say, well, one, if all parties agree it should be, which covers the prospective element. Two, probably, in a case like Judge Dyke's Harvey case where the CCO has been obtained by material non-disclosure or deception. Apart from that, we don't really need to say, since this was consent. So we're in completely new territory about when the jurisdiction, which no doubt exists, to revoke retrospectively should be exercised. I don't follow why you say that the terms of Section 88 of the 2015 Act point inexorably towards retrospective variation.
It is because the backdating of the grant of legal aid means that there is costs protection and funding available for all the work during that period up until the prospective order was made.
Sorry, this is my fault entirely. Can you just repeat that? It means that there's cost protection funding for
all the work done.
Yeah.
Up to, well, including, but certainly prior to the prospective setting aside of the order. So until that order was made. So that means that necessarily during that period, albeit that it was a material change of circumstance that cast a flood of light on what the position was prior to that point, it is a fact that, because of what we now know, the circumstances in which an order can be made are now shown do not subsist, or rather don't have any life prior to that point, prior to the point at which the prospective order was made.
Your solicitors could have done the sequence differently, couldn't they? They could have applied for permission first, then on permission being granted, apply for legal aid, and then there wouldn't have been any need for a cost capping order.
I think, well, I'm not sure to what extent decisions that could have made differently have a bearing on the legal issue before the court. But in any event, my understanding is that the indemnity that Lee had didn't cover any post-permission work. I'm just turning my back for a moment, if I may. Yes, we'll check, but I understand that from my learned junior that the CPRs require the application for a CCO to be made at the same time as the application, or before the court at the same time as permission. We're just checking what the, I think it's CPR 46 from memory, but I think the key point is that the Law Society, who had provided the initial indemnity, had made it absolutely clear that it didn't indemnify in respect of any matters arising after the grant of permission.
I'm being a bit dense. How does that have an impact on the sequencing?
Well, it meant that there could be a period of not being covered for work done.
The period in which the application of legal aid would be made after the grant of permission, after the grant of leave.
Or the post-permission application for a CCO.
But that would arise only if, after the court had assessed the merits very differently from the legal aid agency. The legal aid agency maintained a refusal to, or did refuse.
Well, all I can say is that my solicitor couldn't have predicted what the outcome was going to be, given the history of the decision making.
I'm just trying to explore my lord's point about the sequencing.
Yes.
I mean, because we're looking at an issue which has potentially wider implications than this case. And at the moment, it seems to me that he's right, respectfully, that in principle, you could have a sequence where the application was made for leave. The downside cost risk of that exercise is limited. If leave is refused, well, that downside cost risk has to be catered for, either by an indemnity or out of the funds of the applicant.
May I just?
But if leave is granted, and unless the CPR compel the application to be made at that time, the application for legal aid is then made, and if the legal aid is refused, you seek the CCO.
I don't think that it's possible to be as sanguine about the costs incurred at the permission stage. I'll turn my back, but my understanding that those costs can and often are considerable and were relatively high in this case.
The claimant's own costs, yes, but the protection, which is what we're really concerned with here, against the adverse costs
or both.
Is what I'm focusing
We're overall on the consequence of the on the rationale behind the sequence of the decision making. It's relevant. I mean, that's what the court was dealing with. The court's looking at, why you didn't do things in this order, why did you do it in that order. My respectful submission is highly material to that. Might not be material to the particular specific legal question arising as regards retrospective set aside, but it is material to the question the court just posed, which is why didn't you do things differently?
And I'm not putting this as any sort of criticism. It's the different ways it could be done. I've never before looked at part 46, 17 onwards. It doesn't seem in 46, 17 that it has to be made at a particular time.
My lord, I can assist. It's in the practice direction. It says it must normally be made at the same time as the claim. So.
Oh, right, okay.
I'm very grateful to
yes, thank you. Right, so...
Yes. Yeah. What page is this, please? Supplementary bundle, page 26. Also cast some light on the sequence here. Also, I have to say, just sort of off the top of my head, the appellant would be, and certainly I'm sure PLP, would be highly concerned about any principle which served as an incentive to the legal aid agency to only look at the merits of cases after permission had been granted, on the basis that that there was going to be any disincentive to apply to making decisions until after the permission had been granted, obviously would be highly concerning.
You were saying supplementary bundle 26.
At the bottom of the page, paragraph 7.
Oh, this is in this particular case.
Yes.
The Law Society. Yes,
Yes.
I see.
Yes, and I again, I refer to those matters in response to the court's identification of a potentially different order of play. I don't say it has a bearing on the specific outcome in the legal question that we're concerned with.
Thank you. That's very helpful.
So for all those reasons, we say that the course taken by the, I mean, there's a degree of circularity. If one looks at the chronology of the legal aid decision making, and indeed the witness statement, I think it is of TI in the bundle, reference is made to the constant need to have to apply for legal aid, have it refused, go for a review. I mean, it's a constant. There comes a point at which you just have to crack on and get the matter into court. Particularly where, as here, we're dealing with the interests of a child, a very vulnerable disabled child. And we say that this kind of case was precisely the sort of case that the cost capping statutory framework was decided to ensure gets ventilated. Indeed, as a consequence, notwithstanding the robust terms of the defence, the offending regulation has been amended, and indeed ex gratia payments have been made in respect of this matter. So it's clear that it would be somewhat problematic if there were any disincentive to persons in the same sort of situation as TI or CR in getting their cases into court as soon as they can. And we respectfully suggest that that is also a factor that the court needs to think about when looking at whether, in circumstances where the legal aid agency has been encouraged to think better of its decision making by a grant of permission, that nevertheless that those representatives should be effectively penalised in their ability to recover costs.
Sorry, let me just try and what exactly you're saying then.
I'm saying that I've identified two areas of material to discretion,
Yeah.
and the third area I've identified is the need to ensure that reluctance to make this form of retrospective order doesn't also act as a disincentive to individuals bringing their cases, getting them into court promptly, to have very important issues ventilated robustly. Forgive me.
Yes.
There is I don't know if the court's had an opportunity to turn up Mr Justice Lane's reasoning in the Appellant case.
No.
Which is
That's
in
tab 3.
That's right, it's tab 3, page 34. So this is quite an interesting case because it's a case where the government department Secretary of State for Justice had made an application to vary, with retrospective effect, a cost capping order. And we see why at paragraph 20, the extracted paragraph there from the Secretary of State submissions. The cost capping order had been made apparently without any consideration of the Secretary of State's submissions in respect to the application.
Sorry, which paragraph?
We're at paragraph 20, top of page 37.
Oh, I see, yes.
And the court, Mr Justice then goes through the statutory framework and if we have a look at the issue at the top of page 43, paragraph 48, under the subheading discussion.
Yes.
So here, the court's saying that he's satisfied there's no jurisdictional bar at this point in the proceedings, to the court making an order that retrospectively varies paragraph 4 of the order of 2022. And what he then does is go through a number of factors tending for and against the application of that discretion. And he highlights during that consideration some infelicities in the timing of various pieces of correspondence and the extent to which the parties had or hadn't jumped on any apparent problems with the process. He takes account of the sort of the certainty point, in that case being made by the claimant. Much is also made of that point in the defendant's submissions in this case. However, he concludes at paragraph 63, standing back and having regard to all the matters, I conclude that the circumstances of the present case are of a sufficiently exceptional kind so as to justify at this stage the variation of paragraph 4 of the order of 20 January 2022. And then he varies the order effectively to provide further protection to the, if we have a look at the order on the following pages 46 to 47.
Ms Weston, what are you saying the court should draw from this?
That there will be circumstances where information which wasn't before the decision maker at the time of making the CCO nevertheless will have a bearing on the appropriateness of its terms. So notwithstanding that the information relied on by the grantor of the CCO was correct at the time it was made, information subsequently coming to light justified a retrospective amendment, that's to say an amendment with retrospective effect. That is to say, to cover the costs incurred during the period of the CCO up to that point.
Sorry, I wasn't familiar with this case. I'm trying to get my head around it. It keeps referring to paragraph 4 of an order.
What seems to have happened, if I've understood it correctly, is that instead of putting his or her, I'm not sure who it was at the time, but Lord Chancellor's objections to the cost capping order in the acknowledgement of service, the Secretary of State for Justice chose to use email to the administrators in the admin court, and that didn't work. So when Mr Justice J came to make his decision, he was unaware of that objection. So those were facts that existed. It was administrative oversight. The order was made without consideration of submissions that had been advanced but put in the wrong box. So it's a very different set of facts from ours. It's not a judicial oversight because no one told him there were submissions. He was kind of surprised by the look of it.
No, I agree. My Lord, I absolutely agree. It's a very different set of facts. I'm not...
So really, one could view that case as revisiting the case on the grounds that it wasn't dealt with properly in the first place, which isn't this case.
No, it isn't. But it's the... But what is relevant is that questions about certainty in my respectful submission, or the certainty of the position of the parties, have to take second place to information which places a different complexion on the circumstances concerning whether the mandatory criteria for the order can now said to be fulfilled during the appropriate period. The order that Mr Justice J made was right on the information in front of him. He then got some other information, and Mr Justice then got some other information and decided that an order with retrospective effect, a variation to the order with retrospective effect, should be made. But we are in the similar situation in that, although it's different information, this court now has information which, because of its backdated nature, the backdated grant, does affect what the position is in regard to recovery of costs at the date the order was made.
No one's disputing that.
Yes. Well, Lord Justice Warby, forgive me, asked me what I take from this case, and that's as much as I can take. But it's just an illustration, in the absence of any authorities which are directly on point, on the way in which a retrospective order, an order, that's to say a variation order with retrospective effect, may be the appropriate course when the situation changes.
And it looks to me as though everything was in issue about the cost capping order. Mr Justice J had limited the claimant's liability to 5,000, and the defendants were saying that's too low. The defendant was also objecting to the terms of the retrospective element of the cap.
Yes.
And indeed was saying there shouldn't have been a cost capping order at all. Yes, I see. All right, thank you.
I have to say that I draw my primary support from the statutory framework, and I've made those submissions.
Yeah.
I don't have, because we're in novel territory, an example where the court has been faced with a situation like this.
Yeah.
But what I can do is point to the way in which supervening information may nevertheless result in a backward-looking order.
All right. Anything else from the Appellant?
No, my lord, no. Well, if I can then turn up the my skeleton argument, just to make some submissions, if I may, on the grounds in this case. So just turning up the skeleton at page 29 of the core bundle, subsection D, part D of the skeleton. So we say it was a material factor that, owing to the backdated nature of the grant of legal aid, it was inescapable that at the point at which it was made and during the currency of the order up to that point, the statutory criteria weren't met. So at the point at which it was, the order was made, the statutory criteria were met, and that's how it appeared. Once the backdated grant of legal aid had been granted, the effect of that grant was that, in fact, the statutory criteria can now be seen not to be met. Because there was cost protection and funding available throughout the currency of the order. It wasn't known at the time the order was made, it is now known. So what the skeleton argument does at paragraph 31 onwards is point out that because there is no judicial discretion, paragraph 33, to grant an order where the statutory criteria are not met, the effect of the backdated grant of funding was that it was now known that there was cost protection and there was funding at the date of the order. Sorry, that there is cost protection and funding for costs incurred at the date of the order. So it was of effect. The backdating makes that grant of funding of effect, but that was only known after the CCO was made. I don't repeat what's said in the skeleton argument there, but it's simply there's submissions which largely go over the territory I've already gone on the statutory framework. I would simply point out at paragraph 35, top of page 14, that the purpose of the reciprocal cap, 1, 2, 3, 4, 5 lines down, is it intended to balance the litigation risk faced by defendants where a CCO is granted. So in my respectful submission, the statutory purpose of the reciprocal cap, if the whole of the CCO was gone, was no longer a factor. Because, and we note there that the statutory scheme doesn't provide for a cap on the defendant's cost risk if the claimant has cost protection by other means than the CCO. Second ground on irrationality, we've relied on the concept of irrationality in two senses there. One, in that there's an irrational failure by Mr Ockleton to take relevant matters into account. And also in the sense of his conclusion being legally unsustainable on all the available material. That's a high threshold, I accept. But we say that for the reasons set out at paragraph 37 onwards, most of which I've already gone over in my oral submissions, Mr Ockleton wasn't entitled to reach the conclusion he did. Key in the submissions that I've made on the rationality of Mr Ockleton's decision is the fact that Parliament, paragraph 41, plainly intended to promote access to justice for applicants for judicial review of limited means, and the effect of the order of Mr Ockleton is not to promote access to justice. Ground 3 is effectively a reasons challenge. I don't think
does it really lead anywhere?
No, exactly.
The last thing you want is for us to send it back to...
Absolutely, yes.
Yes.
And I do wonder whether, in fact, it fairly reflects the order that was made, because what Mr Ockleton does very clearly in his order is state under reasons. It seems to me the defendant's detailed reasons for making the order and form are correct. And speaking entirely for myself,
yes,
it isn't difficult to understand the clearly set out reasons in the defendant's response.
Yes, but we say that this isn't the sort of discretionary costs case where it's sort of competing submissions on the granular conduct of the hearing and that sort of thing. This is a case raising what Lady Justice Lang described as an important point of principle, and that cried out to be dealt with by Mr Ockleton. It wasn't. It's plain that on the claimant's analysis, of the mandatory provisions of Section 88, that the assertion in the defendant's representations relating to the denial of the reciprocal cap had to be analysed in circumstances where there was no longer any need for a reciprocal cap, because the underlying order in respect of which the reciprocal cap was imposed would be going as well. And then ground 4, obviously our submission is that the conclusion was wrong in all the material circumstances. And we'd obviously invite the court to make the order that we had initially sought, because it was wrong in that it was in error of principle. The principle being that the statutory framework and the circumstances of this case, the way in which, in the particular circumstances of this case, the order would act as a disincentive to those bringing important public interest matters to court, and the way in which the statutory framework was set out in mandatory terms, all militated in favour of the order that the appellant was seeking. May I just turn my back for a moment?
Of course.
forgive me. My instructing solicitor had some additional points to make about the sequencing, but I think it's fair to say that the explanation that I've given about the nature of the limited underwriting of the cost liability by the Law Society, the fact that that was limited, highly limited in scope, and the terms in which the CPRs are expressed, all militated in favour of things being done in the order they were. Simply put, if the defendant had made the right decision in the beginning on the question of the merits, we wouldn't be in this situation at all. I don't go so far as to say that, and I don't challenge that decision, but there is, as I say, a point at which litigants have to get the matter into court, and there, as the history of the legal aid decision making in this case, indeed in this case as well, in this appeal, funding was refused and had to go to an independent appeal, and therefore an application was made in respect of timing. So against that background, bearing in mind we're dealing with access to justice, and that's the whole purpose of the CCO framework, these are all matters which bear heavily on the nature of the order that should be made in this case. May I just turn my back?
Of course.
Those are my submissions unless I can assist.
Mr. Percy? Right, we'll take a break at this point and see where we go from here. Thank you very much, Ms. Weston. You've been most helpful.
Can we just have a quick huddle?
Mr. Birdling, we would like to hear you on grounds 1 and 2. We don't think that grounds 3 and 4 add anything to the mix.
Thank you.
And you can take it, I hope, that we understand the facts.
Yes. Well, my Lord, I'll be as brief as I can. I don't understand that the principle in terms of how this court ought to approach grounds 1 and 2 is in dispute. It's not for the court to make the order it would have made if it were sitting as a first instance judge. It's rather to determine whether the judge erred in principle. And I've set out in my skeleton argument, it will be well familiar to your lordships and your ladyship, that it's a very wide discretion that a first instance judge has, both when making a cost determination, if that is what this ought properly to be characterised as, or a case management, interlocutory case management decision, if that is what it ought properly to be characterised as.
I think you would accept, wouldn't you, Mr. Birdling, that as Weston, just before the end, made what seems to me a fair point. This is not the sort of costs decision made by a trial judge who sat through days and days and days of evidence and reaches an overall conclusion. Mr Ockleton made a decision on the papers, and while it is a first instance decision, it's not the sort of effectively unappealable costs decision made by a trial.
My Lord, I accept that point so far as it goes. It certainly isn't the case that I'm saying that this is a judge who had heard an entire trial and therefore was intimately familiar with the facts. What I do say is that there are 2 points. One is that I can take your Lordship to the passage in the Bug Life decision from this court. The Master of the Rolls made clear that it's not the fact that it's a trial judge that made the decision, that it's an administrative court judge that made the decision. And administrative court judges do have considerable experience in making cost-capping orders. And the point of principle from the Master of the Rolls there, and I can give your Lordship the reference,
Yes.
I know the junior will give it to you, that it is administrative court judges that have that expertise. So it's a counsel of caution against appellate interference on that score, but I accept that the rationale for that is different. Second point is that when it comes to reasons, I know your Lordship doesn't want to hear from me on that, but you may need to address that in your judgment. And the authority which is cited in my skeleton argument makes 2 points. One, that when one is dealing with deference in that context, one is according a considerable amount of deference because of the fact it's a first instance judge, and then there is another layer, as it were, where that's a decision from the judge. Sorry, let me give your Lordship the reference, because I think that's going to be easier than dealing with it in that way. It is... Oh, I forgive you. Forgive me, my lord. It's not. It's not at all in the reasons context. It is actually in the cost context. So let me take your lordship and your lordships and your ladyship to it. It is. I'm not sure if your authorities bundles are tabbed. If they are, it's at tab 13. But it's
Yes.
page 295 of the authorities bundle, and it's paragraph 162 and 163. Where the court there is drawing the distinction that I just drew. 162 is the general caution about discretion when you're dealing on an appeal from a first instance judge. And then 163, so it's page 295 of the authorities bundle. So there's in effect 2 layers. One is the general admonition about not micromanaging lower court judges' decisions, which your lordships and your ladyship will be familiar with. And then the second is that applies a fortiori when one is dealing with a decision of a judge, as Lord Justice Bean put it, had sat through a trial and heard all of the evidence. But I do accept that we're in that former category where you have a decision of a first instance judge, but not one that has any special familiarity with the facts. The reference for Bug Life
I think it's 31.
is page 31.
Paragraph 31.
And
It's Bug Life paragraph 31.
you quoted Bug Life paragraph 31 in your skeleton.
My lord, yes. And the point there is that it's a deference to expertise, and that the administrative court judges are experienced with this particular type of order because they see it on paper and they see it orally all of the time. So that's what I say there, but I do accept my lord's point about the absence of particular familiarity with the facts. So that's all I want to say about the proper approach to this appeal. Now, my learned friend's ground 1, which I'll take first, is my learned friend's attempt to identify what I could describe as a hard-edged error of principle in the learned deputy judge's approach. And my learned friend's position, as I understood it, is not that it was a mandatory requirement that where the statutory preconditions to the making of an order cease to be applicable, the order must be discharged, but rather, as my Lord Justice Bean put it, it points inexorably in that direction. So that is what I understand the case to be. And in my submission, that's flawed for two reasons. The first is that it's to misunderstand what Section 88 of the 215 Act requires.
Can you just slow down?
So, I'm sorry, my
That's
lady.
all right. That is to misunderstand what Section 88.
Of the 215 Act requires. And the second is that the approach for which my learned friend contends would have the effect of subverting rather than upholding the policy, the parliamentary intention which underlies the cost capping order regime. So to take Section 88 first, I will ask the court to turn that up. It's at the first tab of the authorities bundle at page 4. You've seen it already because my learned friend took you to it. My learned friend took you to Section 88, subsection 1, which makes clear this is a code for the making of cost capping orders. But what my learned friend rested her case really on was subsection 6, and these provide jurisdictional provisions, in effect a gateway that the court must pass through before there's jurisdiction to make a cost capping order. And it's important to look at what that requires. It requires the court to be satisfied at the time of making the order that the matters set out in A to C are satisfied. If the judge is so satisfied, there's jurisdiction to make a CCO, and if the judge isn't so satisfied, then there's not. There's not a discretion to make one at all. So this is a jurisdictional gateway provision. Now, what this doesn't do is provide that a CCO is in some way revocable if at some point in the future, during the currency of the litigation, they may no longer be satisfied. It may, as a matter of discretion, lead to an application where a court could vary it. That's not in dispute. But the court doesn't get any assistance from here about whether or not that's presumptively the case or is mandatory. And indeed, there's many reasons why the criteria may no longer be satisfied in the course of litigation. It may become apparent because of disclosure or some change in the law that actually the prospects of success are rather greater than the claimant anticipated at the outset, such that they may well not be acting reasonably by withdrawing the application of the CCO to be withdrawn, or in fact they may not want to, because they might view their prospects as rather better and their representatives' prospects of cost recovery as being rather better. That's one circumstance in which the criteria may no longer be satisfied. Or they may cease to become public interest proceedings, because, for example, the issue in the case, which gave rise to that public interest, may have been resolved or fallen away, while other issues remained. Or that issue may have been resolved in a different case, such that this case no longer was an appropriate vehicle to ventilate it, or it was no longer necessary. And developments such as these are in the nature of litigation. But what they don't do, and what Section 88 doesn't require the court to do in light of those developments, is go and assess whether, on a continuing basis, the CCO remains appropriate. And as against that, what my learned friend says is that the legal aid certificate in this case obviated, so that my learned friend says something, I think, a bit more subtle here, which is that actually it's not that there was a change of circumstance, although there was, but rather that change of circumstance in some way related back to the very commencement of the litigation, such that when the legal aid certificate was made, what that actually meant is that the judge, when the judge made the order at that time, actually the criteria were properly met then. And that, in my submission, is a logical fallacy. And you can see that when you trace through the documents. My learned friend accepted that the order was validly made, and it was validly made on the basis of an application made by the appellant, where the court was told in terms that the application, the judicial review, would be withdrawn if a CCO wasn't made. That was what the court was being told unambiguously in witness evidence. So the court was plainly saying jurisdictional criteria were met, and it's simply factually wrong in my submission to say that that means that the statutory criteria were not satisfied for the entire currency of the litigation, which I think is the more subtle way that my learned friend tried to put her case this morning, because they were satisfied at the material time, which is when the judge made the order, and the consequence of that was that from the date the CCO was granted, the appellant enjoyed the cost protection which the CCO provided. Now, the quid pro quo for that cost protection, which did apply for the period until it was varied, was the reciprocal cap. And Parliament has provided in section 89.2 of the 2015 Act that where the court makes an order limiting a party's costs exposure, they must make an order limiting the other party's exposure. And it also meant, importantly, I'll come on to develop this in a bit more detail under the head of policy, but it also meant that the appellant's representatives were well aware at that time that they would not be recovering at commercial rates, even in the event that they were successful. And that, I submit, is the first answer to ground one, which is the appellant simply wrong as to what section 88 of the 2015 Act requires. Now, that isn't, in my submission, the only difficulty with my learned friend's proposed approach. There's an additional difficulty, which is that the approach if adopted would frustrate the policy intention underlying the CCO regime. There is guidance from this court as to what that policy intention is. And could I ask your lordships and your ladyship to turn up the Alan Kane case, which is at tab 8 of the authorities bundle, page 148, a very short passage. So 148 is where the case starts. The relevant passage is 182. And it's paragraph 148. Could I ask the court to read that, please? So that's from the judgment of Lord Justice Henderson. For completeness, Lady Justice King and Lord Justice Irwin agreed, and the references for that are paragraph 122 and 124. This was a cross appeal on costs that Lord Justice Henderson was dealing. So what the court there is acknowledging is that the purpose of the regime is to provide certainty to the parties as to their potential liabilities and indeed their potential scope for cost recovery at the outset of judicial review proceedings. And that's important because the purpose of it is that parties who would otherwise be inhibited from taking steps in litigation will know where they stand. And that policy in my submission is undermined is, if my learned friend contends ought to be the case, the courts were presumptively or ought more readily to be revoking CCOs which were made on a properly informed basis at the start of proceedings on the basis that something subsequently changes. And in my submission, that is entirely consistent with the two first instance cases that my learned friend referred to. I'm not going to take you to them, but the first was the Harvey case, And as I think the court is aware, that was a case where there was material non-disclosure. Even then, if one looks at how His Honour Judge Dyke, the Deputy Judge, dealt with it, it was quite clear that that policy of certainty was at the heart of how the court approached it, because there was also in that case an application to revoke or vary the CCO on other grounds on the basis of subsequent developments. And the court made clear that they were not going to be sufficient grounds, because it was really only because of the material non-disclosure that one was into the territory where the court might consider revoking. And the second is the Atlu case. Now, the position is in that case was actually slightly more different to this one than was perhaps apparent from the exchange between the court and my learned friend, because there Mr. Justice J, who had made the paper order, explicitly provided that the order was a contingent one, because he hadn't seen any representations from the defendant. He thought that was odd, and he directed that if the defendant wanted to have anything to say about it, they ought to do so, and then the claimant would have the last say, and it would go before the judge for a final determination. Even in those circumstances, where whatever certainty one might get from the order was expressly qualified, the court was, as my learned friend explained in the passages she took you to, clear that it was only in exceptional circumstances that one would be revisiting an order. So I'd ask, in fact, there is a statement of the general principle that one finds in that case that I will take the court to, because I think it's a statement that I'm going to ask the court to endorse. So it's behind Authorities tab 3, and it's at page 43. And can I ask your lordships and your ladyship to read paragraphs 48 to 51, please?
Yes.
So I'd ask the court to endorse those statements of principle in those paragraphs. Of course, in that case, as my learned friend explained, the court went on to decide, because of the exceptional features of that case, it was appropriate to make some modest modifications to the order. But there's no dispute between my learned friend and I that there's a discretion to vary the order in appropriate circumstances. Indeed, the respondent consented to the variation of the order in this case. But in my submission, the thread that flows through both of those cases, and indeed the legislative provisions, is that certainty is what these provisions are designed to achieve. And a mere change of position doesn't justify a retrospective variation of the CCO, still less, as my learned friend would have it, point inexorably towards one. So that is my answer to the appellant's first ground.
So if, in the circumstances that I put to counsel, the claimant comes into or gets access to a large sum of money that wasn't available before, which could be one way you could view what's happened here, would you say that it's not open to the defendant to come back and say, well, things may have been, the gateway provisions may have been satisfied at the time, but things are very different now. Can we have it all set aside so that our prospects are better of getting our money back?
As a matter of jurisdiction, the answer is no. I mean, it would be
All
open,
the
it would be
arguments
open, but
yeah.
as a matter of discretion, I would say that it would have to be something extraordinary to justify a retrospective variation in
Yeah.
those circumstances, but for parity of reasoning with the respondent's position
So
here.
an order like Mr Ockleton's order might be.
Prospectively, yes, and that indeed is the effect. So there's actually an important point here, because my learned friend has said that the scope of the legal aid cost protection is the same. Actually, the legal aid cost protection itself envisages circumstances where what you might have heard it colloquially referred to as the Pools order, because it's not absolute cost protection that one gets when one has a legal aid certificate. It's a qualified cost protection that you can only, if you have a cost order against a legally aided person, recover in accordance with provisions in the regulations. So if there is a material change of financial position at some point along the road, there may well be cause for recourse by a successful party. And in that respect, the cost protection that the appellant achieved by getting the legal aid certificate was materially different from that which they obtained under the CCO, which was absolute within the terms of the CCO. So, my lord, that is what I would say as a point of principle. The respondent's approach in this case was and has always been that it was appropriate for the cost capping order to be varied prospectively, because that was what the appellant wanted and the respondent acquiesced. So that's what I say to that point. My lords, my lady, can I assist you any further on ground 1?
No, thank you.
So I move then to ground 2. I appreciate that your lordships, your ladyship, have asked me not to address grounds 4. In my submission, ground 4 is effectively of a piece with ground 2, so I was proposing to deal with them together. To respond to how my learned friend has advanced her case under those grounds this morning, I propose to take my submissions in 3 stages. The first is to look at how the court came to make the CCO in the first place, and I'll do this quite quickly because you've already been taken to many of the key documents. And that also interfaces with the 2 legal aid applications, because a point is taken against me, the effect that there is something sinister or untoward, if I can characterise it that way, in the legal aid agency's approach. It was put a bit more softly this morning, but it was put in terms of perverse incentives in writing, and I want to knock that on the head. Second, I'll take this again quite shortly, because I think we've got some common ground now. Look at the parties' respective positions before the deputy judge, and then finally look at, by reference to those competing sets of submissions, how in my submission the variation order of the deputy judge was squarely within the scope of his very wide discretion and didn't admit of any errors of principle. Turning first to the circumstances in which the court came to make the CCO, as your lordships, your ladyship heard this morning, the first application was made not by the appellant's solicitors on this application, but her previous solicitors, and that was submitted as an emergency application. Now, an emergency application is one that can be made on the basis of limited information in a more informal manner than usual, and leads to a time-limited order, effectively to provide for urgent legal aid, legal services to be provided before a substantive order can be made. It's because of that that there was no right of appeal. And the application's not in the bundle, but it was made on the 27th of October 2021. It was dealt with urgently, as one would expect, and a decision was made on the 3rd of November. So at that point, the appellant's representatives could have submitted a substantive application, and that would have given rise to a right to a fresh determination, a review, an appeal to an independent funding adjudicator, but they didn't. What they instead requested is a review of that decision, and it was that resulted in the decision of the 29th of November. The basis for the refusal, both initially and on review, was that the prospects were poor, and that is a defined term in the legal aid merits regulations, meaning that the merits were assessed at being less than 45%. the next point we reach in the chronology is that the pre-action protocol letter is received, and I'm going to ask the court to turn that up. That is supplementary bundle, page 11.
Yes, 13th December.
Yes, so thank you, my lord. The first point I was going to ask the court to note was the date. So this is 2 weeks after legal aid was refused, and you can see from paragraph 1 that new solicitors have been instructed. Then you read on to paragraph 2, you see that they were planning to issue the same day or the next day because they were already outside the long stop date. And then there's an acknowledgement further on that they'd left it to the last minute, and they apologised about not engaging about a cost capping order earlier. I make those points because in writing there had been some suggestion that, that the defendant had failed to engage with requests to agree a CCO, whereas it was just a feature of the time that was involved. Then one looks at the evidence in support of the cost capping application, which is in due course made. So if I could ask the court to turn forward, please, to page 24. This is the witness statement of Daniel Rourke. You see that he's a solicitor, the Public Law Project. Paragraph 2, you see what's sought. And note there that what's sought is a limitation whereby the reciprocal cost cap will be inter partes rates charged by the government legal department. So there's an acceptance there that the appropriate reciprocal cap is the rates charged by the government legal department and not commercial rates. We then get on to an explanation of how the jurisdictional criteria are met. But could I ask the court please to read paragraph 5? Then we see the indemnity, and then if the court reads on to paragraph 9 rather, I could ask the court to read paragraph 9 please. And then paragraphs 10 to 13 over the page. So what the court was being told was, first of all of the claimant's representatives had agreed to act at the discounted rates set out. Second, that those rates, that assessment had been made by reference to the need to ensure the sustainability of PLP's casework. And third, and importantly, that the claimant's representatives had actually given thought to what would happen in the event that permission was granted, and indeed set that out. And what the court isn't told is actually, in that case, what we'd be doing is applying for legal aid, and we expect we get it, and we'll be coming back and saying this order ought to be revoked because it's not necessary. There's no mention of that. On the subject of rates, I pause here to answer a question that my Lord Justice Bean asked my learned friend about whether there was any appellant guidance about the appropriate rate. And I'm going to answer that question not by reference to an appellate decision, but to a decision of Mr Justice Chamberlain that the court has in the bundle.
Is this the Western Sahara?
The Western Sahara case. It's at page 221 of the bundle. I don't ask the court to turn it up now, but there the court will see all of the authorities that set out the proposition that when seeking a CCO, counsel can expect to be remunerated at a modest rate. It's expressly not the JFS category where the expectation is that there'll be remuneration at a commercial rate. That was, as my Lord Justice has been recognised, an entirely different situation. So at that point, the CCO is granted. I won't ask the court to turn up the CCO again, but there's two important features. One finds, first of all, at page 96 of the permission order, a reasoned explanation from the deputy judge as to why he considered the grounds to be properly arguable. And second, one finds at page 97 the court's reasons for making the CCO, and in particular paragraph 6c regarding the reciprocal act. There's no application by the appellant to renew that application, vary it. That was the order that the parties accepted, and on the basis they moved forward with. Following the grant of permission, however, there was a change of position from the claimant. And they wrote, first of all, if I can ask the court to turn up the supplementary bundle at page 30. So this is a letter shortly after grant of permission. And we see that they're saying that their position is they now ought to be backdated legal aid funding. And then at paragraph 3, you see the underlining. They've recognised that there are arrangements in place for decisions on legal aid in respect of decisions against the legal aid agents to be made independently of the team handling the litigation. And they've requested confirmation that that would be the case. And then if court turns on to page 32, you see that that confirmation, unsurprisingly, is given. And the application is successful. And the court can see that at page 36. First point to note about the certificate that you'll find at page 36 is that the appellant had applied for, with their new solicitors, a substantive certificate, not an emergency certificate as earlier, and also it was backdated to the 10th of December 2021. Now, it has been suggested, it wasn't pushed this morning, but it was suggested in writing that this was in some way a concession that the earlier refusal in November was unlawful. Now, that is incorrect.
You've made that clear in your standard.
But if I don't need to say anything more about it, I won't. The point is simply you have two legal aid applications determined by different decision makers, and a different decision is reached, and different decision makers can rationally make different decisions on different facts, and that's all perhaps I need to say about that. But it's quite often said in these cases the reason why some ink was spilt in writing is that it's an accusation that is quite often levied against those instructing me, and they wanted to make clear that there are robust processes in place to determine independence, and of course decisions are subject to independent review and oversight by judicial review. So it's an allegation that my submission ought not to have been made. But even stepping back and looking at the broader context, putting to one side an error or alleged error by the legal aid agency, there are a number of reasons why an individual might become eligible for legal aid in the course of proceedings, but not at the outset. Their income may drop after commencing proceedings. They might lose their job. Some catastrophic event may happen, which means that they satisfy the means requirements during the course of litigation that they didn't at the outset. There may be some matter that objectively improves the prospects of success, such that the merits criteria are met when they weren't at the outset, whether because during the normal course of disclosure some evidence arises, or whether there's some development in the law, or where, as here, the case passes the permission hurdle. So the mere fact that the circumstances such that legal aid is now available is not in some sense extraordinary or unusual. So with that, the application to vitiate the CCO was made. Now, I don't want to take court through all of the material, but what I do want to do is just look at two documents. Because what happened is, the chronology is this. There was a correspondence saying that the appellant intended to make an application to vary the CCO. What the respondent said is, well, we'll respond in due course, but to put a marker down, we think it ought to be prospective only. And then you get, if you look at page 51 in the supplementary bundle, a letter from the Public Law Project setting out their submissions directly on this point.
21st of March.
Yes. Won't ask you to read that now, but that's what PLP was setting out its case. And then one gets the letter you've already seen at page 53, which is the respondent's response to that. And this is important because, as my lady noticed, this is the letter that the judge accepted in his reasons. At page 56, what one sees is that the Public Law Project have written again saying they have nothing to add and they want it placed before a judge as soon as possible. So that was what the judge had before him. He'd been told, please do this on the paper with the agreement of the parties, and he'd been given succinct but appropriately detailed representations on the point that was for him to determine, the point that was in dispute, retrospectivity. And my submission is that in circumstances where a judge on paper is asked to make a decision, when you have two parties making submissions on a very narrow issue that are crystallised in those submissions, it's entirely unsurprising that a judge dealing with an application of this type dealt with it by short reasons preferring one party's submissions over the others. And furthermore, in my submission, the judge's acceptance of the reasons he set out in the respondent's letters was well within the scope of his discretion, did not admit of any error of principle, and resulted in an outcome that was entirely lawful, in which this court oughtn't to interfere with. I won't take the court through all of the reasons that were set out in that letter, but it's the key matters that the appellant has sought to identify as errors of principle today. So there can be no suggestion that the judge didn't turn his mind to these matters or fail to have regard to relevant considerations. The parties had put before the court all of the matters they wanted the court to consider, and the court had made a call one way, a way that the appellant doesn't like, but one that was well within his discretion. And that, my lords, my lady, is in my submission the answer to ground 2 and indeed to ground 4. So unless I can assist the court further, those are my submissions.
Thank you very much, Mr. Bradley. Miss Bird? Miss Weston?
Just a couple of short points, if I may. Just going back over the history of what came before Deputy Judge Ockleton. I think my learned friend missed out the stage where Mr. Justice Lavender, on request by the defendant, granted further time for the defendant to put in their detailed grounds of defence and make further submissions about the CCO. So we see that order at 75 to 76 of the core bundle. If I could ask you to turn that up. key part is at the top of page 76. So this is what happened in response to the applications that my learned friend has just taken the court to. We can see the order of Mr Justice Lavender says, defendant and the first interested party wish to, this is top of page 76, to reply to the claimant's most recent application in their detailed grounds of defence. I'm prepared to give them that opportunity, recognising the mature reflection on the points made by the claimant's solicitors in the letter of 21st of March 2022. That's the letter to which the court was just referred by my learned friend. Might narrow the area if any of dispute between the parties. So it was following that order that the defendant then put in detailed grounds of defence, notwithstanding that they had indicated in writing that they were contemplating considering whether or not to amend the offending regulations, but that correspondence is all in a bundle. But it was on receipt of the detailed grounds of defence, which included submissions in relation to the form of order sought, that Deputy Judge Ockleton made that decision. In response to my learned friend's submissions this morning, there is in my respectful submission a large lacuna in the reasoning being advanced by the respondent, and it's this. On the analysis that the respondent is seeking to advance, the backdating of the grant of funding is of no effect. There is no answer to what is the impact of the fact that the decision to grant backdated funding has effect at the date when the CCO was made, in that there is no need for the CCO because there's an alternative source of funding for that period. Nothing that the respondent points to in Elaine Kane comes close to being of any assistance on that argument. The key part of paragraph 148 in the judgment of Lord Justice Henderson in Elaine Kane says, the underlying public policy which underpins the cost capping regime in the 2015 Act is of promoting access to justice in judicial review proceedings which satisfy the test of public interest proceedings.
Yes.
That it's promoting access to justice. My respectful submission is where the legal aid agency has a process of recognising when it needs to revisit its decisions on the merits of an application for funding by backdating that application. The legal aid agency is taking its own steps to remedy the potential injustice of refusing funding in meritorious cases. It's right that if the legal aid agency had made that decision from the off, there would have been no need and indeed no basis on which a CCO could have been applied for at all, because the statutory criteria could not have been met. The claimant, nothing in which the respondent submits answers the point about the backdate, the effect of the backdating of the grant of funding. We are not in the position, as Lord Justice Warby identified, of somebody suddenly coming into a windfall because there is no sense in which that money was available prior to the point at which it was received. Having said that, in some circumstances, it may well be the right order to make a retrospective variation. I don't say that it wouldn't, because I certainly don't seek to close down the court's discretion in that way. But in the context of a backdated grant of funding, in a very real sense, that is money which is available to cover costs already incurred. It's fundamentally different. It's a different set of circumstances. Finally, the appellant is right to say that the consequence of the order made by Mr Ockleton is a windfall for the respondents. Why? Because in circumstances where the legal aid had been made available, or that the decision had gone favourably, not in a backdated sense, but at the date in which it was applied for, the defendant would not have had the limit imposed on recoverable costs in the event that the appellant was successful. That is a bonus which the defendant has obtained through the process, and I certainly don't make any allegation of impropriety. It's a fact. The optics of that, where the respondent is also the government department that refused funding in the first place, in my respectful submission, raise concerns about perverse disincentives. And that is inescapable in the particular circumstances of this case. So we are here not simply because of a change of position by the appellant. We are here because of a particular set of circumstances, as a consequence of which the statutory recourse to a CCO was necessary at the time in order to bring the important underlying matter to court successfully, ultimately. And the terms in which the CCO order were made and the mandatory requirements for the making of the CCO order should, in my respectful submission, be viewed as intimately connected with and relevant to the circumstances in which legal aid was refused in the first place and the impact of the backdating of the grant of legal aid funding. And the reason is because it must be right that the legal aid agency has recognised that that initial decision was the wrong decision. Those are my submissions in reply.
Thank you all very much. You've been very helpful, very concise. We will reserve judgment. As soon as we can, we'll send out a draft counsel in the usual way. Experienced counsel here will know this, but I still expected to say it in each case. 2 points about the draft judgment. The first is that it's subject to the limits on distribution and publication identified in the Counsel General for Wales's case. And secondly, it's sent out for the correction of typos and obvious factual errors, not for the case to be re-argued. We're very grateful to all of you for your oral and written submissions.